All right, so a little bit about myself. Right now, I'm a current board member of the National Lawyers Guild. Uh, I just finished law school last year. Got my JD. I have a Bachelor of Arts in Legal Studies. I served in the Navy for 6 years. I was one of the original organizers for Occupy Wall Street in New York City. Um, I've been arrested numerous times. I was a legal observer in Standing Rock. And right now I work at a civil rights law office in Sacramento, California. We mostly deal with police, excessive force, police shootings, um, false arrests, things like that. Very important disclaimer. I'm speaking from my experience and knowledge. Nothing I say should be considered legal advice. So if you have any legal questions about your specific situation, please consult an attorney. All right. So who are we? Who's the National Lawyers Guild? You'll recognize us by the bright green, ugly hats that we wear at every protest you'll see around this area, at least. Sacramento chapter is pretty active. So is the Bay Area. But any protest, supporting civil rights or workers, you'll usually see green hats there. And we are there to watch the police and make sure people know what their rights are. We're gonna skip this slide, but I guess we'll go over it. Usually I give this is my first time doing a web training like this. So we're seeing how it goes, but this is more for people who would be at the live trainings. Some people wanna like give a whole 10-minute story and try to discuss their case and try to get legal advice. And I have to interrupt them and have them focus on a question. So if anybody has a question or any comments, feel free to write them in the chat window. There should be some option around your screen to enter the chat window, and you can type your questions and I'll be monitoring it here. Go ahead and just type them in whenever you want. You don't have to wait for anything. I like to have that back and forth and discuss things as they come up and while we're on the subject. All right. So what are we going to be going over? So let's get over some misconceptions right now. I'm not going to teach you how to get out of a traffic ticket or how not to get arrested or how to win an argument with the police. All right, that's not what this is about. I'm going to tell you what your rights are, how to invoke them, to give yourself the best chance of winning in the criminal justice system. So the big one is how to remain silent. What does that mean that you have the right to remain silent? And unfortunately, we have to go over this. This is a real thing, but how to increase your chances of survival during a police encounter. We all know they're overarmed and undertrained, and there's certain things you should do when having a police encounter. So I like to think of the law as a game, and like any game, there's a set of rules, and if you don't know those rules, you're gonna lose. You're gonna lose every time, and that's the way our legal system is set up. They don't teach you what the law is in high school. They don't teach you it. They don't teach you that in college. If you don't take the time to look it up for yourself or attend a training like this, you might never know. A lot of things that I'm going to be talking about are new to most people. And that's unfortunate because that means the public at large is at a loss. And that would be a big reason behind the numbers in our criminal justice system and prisons. So this is very important. Your rights versus reality. And this slide, it took me a long time to figure out how I wanted to word this concept. And this is the best I could come up with. Your rights are defended and enforced in court, not on the street. The interaction you have with the cop on the street, the cop can do whatever he wants. And we really don't have a choice. If you don't do what he says or she says, the officer, they might hurt you. And that's just that's the world we live in. And I'm not saying this because I agree with it. I'm just saying it because that's just how it is. So a lot of the things I'm going to be saying today, I don't agree with. So don't take that as an endorsement. I'm telling you what the rules of the game are, and we can agree or disagree with those, but the important thing is that we know them. So the police have a duty to respect your rights, but they have have a duty to respect your rights, but they don't have an incentive to respect your rights. Internal affairs. When you send something through internal affairs, it's a joke. They're investigating themselves. Of course, they're going to say they did nothing wrong, unless it's something. So what I've seen is if it's something super minor, they might hold a cop accountable if it's violating their own internal policy, administratively, like the officer comes in late or doesn't check in on time or does something wrong procedurally, they might get written up. But when it comes to an officer violating the rights of a civilian, when their action goes outside the department, that's really when they want to close up and insulate their officers. It happens all the time. We, at our office, we've submitted numerous citizens complaints to IA for investigation with evidence proving everything we're saying, and they'll still come back saying that the officer is exonerated or unfounded, or that the charges are unfounded. And yeah, we don't know. There's nothing really we can do. Let's see. Police and district attorneys work very closely. And so the district attorneys are hesitant to file charges on any officer. So I have a little note right here. The Sacramento DA's office has never filed charges against a police officer in the 33 police-involved shootings, including Joseph Mann and Stephon Clark. Let's see. Even if you sue an officer for violating your civil rights, they're not going to pay a penny. So that cost is passed on to either the taxpayers or through an insurance pool that the department has set up. The officer you're suing, they won't pay a penny. They probably won't get anything put in their file. It'll be public court record that they were sued. Possibly the settlement will go on record, but they won't admit fault. And it's really that the civil rights system in this country was toothless to begin with, and it's becoming more and more toothless as these cases go through the Supreme Court. Things like qualified immunity is a huge block when it comes to pursuing these civil rights cases. And I'm not going to get into what qualified immunity is, but if you are interested, you can look it up. It's infuriating, but it's a little beyond the scope for this training. It's rare that an officer will go to trial for these cases, either criminally or civilly. In a criminal case, you need a unanimous jury, and it's hard to find a jury of people without one person who will that has that mentality that I will support the police no matter what. That's a rare jury to find. So that combination, the IA doesn't hold them accountable, the DA doesn't hold them accountable, the jury won't hold them accountable. That's why we see such rampant abuse when it comes to police authority, because no one's holding them accountable. They don't. We don't. We need something different, because at every level they'll get away with it. And that lack of accountability is going to lead to more and more abuse of authority, because they know they're going to get away with it. All right, so what incentive does the police have to respect our rights? There's the exclusionary rule. This is a judicially made rule that was defined in two cases, Mapp versus Ohio and Miranda versus Arizona. Miranda versus Arizona is where we get the Miranda rights or Miranda warnings, which we'll go over in a bit. But what the rule says is evidence collected illegally by the police is not admissible in court. Any evidence that was the fruit of the gathering of illegal evidence is not admissible in court. What that means is the search of a car, just for an example, the search of a car is illegal, and they might find a drug paraphernalia on the floor. That ordinarily would have given them probable cause to search the whole car. But if the original search was illegal, even though they found that pipe, anything else they found illegal that was the fruit of that first illegal search is not admissible either. So anything they find along that chain won't be admissible. Also, stuff that could be subject to the exclusionary rule, searches, confessions, seizures of evidence, arrests, they all have to be conducted legally. And if it's not conducted legally, there is a chance that the attorney may be able to get it, the defense attorney will be able to get it dismissed or removed from court. And if you have a big piece of evidence that's not allowed in court, then the charges probably are going to be dropped. And I put here a real world example of an extreme exclusionary rule case. The Weather Underground was a group of militant activists during the Vietnam War who would bomb government buildings. And the FBI was searching for them for years, over 10 years. They finally turned themselves in, and as they were preparing for trial, it was discovered that the FBI used illegal wiretapping and illegal searches to gather evidence. And all the weapon and bomb-related charges were dropped because the evidence was so tainted by the FBI that none of it was admissible. The charges that were admissible, they agreed to a $1,500 fine and 3 years of probation. Bill Ayers, many people know, is now a highly respected professor at the University of Chicago. This is after bombing government buildings. All right, so the FBI tainted their own evidence, and yeah, he both of them got away with it. So that's a real world example of how that works. And so and think of it like this: if it'll work for people who bombed government buildings, it's going to work for a petty drug charge that was subject to an illegal search. So that's how powerful this rule is. But check out that note I put at the bottom, that the only real incentive the police have to do their job legally, it's not the fear of getting in trouble, but it's because the court might not let them lock you in a cage and take your money. That's why. That's the incentive. All right, there's really no other reason for them to do their jobs properly. Maybe they might have some administrative punishment, but that's it. And feel free to ask questions. I see the chat's pretty empty, but if anybody has a question, feel free to ask. All right, so when we talk about the police, who are we talking about? Um, as a general matter, we're talking about anyone who puts themselves out in the position of legal authority. Usually, they're wearing some kind of uniform, some badge. That includes local police here in Sacramento. That would be the Sheriff's Department, Sacramento PD, state police, California Highway Patrol, federal agencies like the FBI, DEA, ATF, DHS. Um, Security guards could be considered police in the context of what we're going to talk about here too, because they're putting themselves out in a position of authority over you. There's a thing called the shopkeepers rule that lets security guards or shopkeepers detain you if they have probable cause that you stole something. There's also citizens arrest type rules where if you commit a felony, a citizen could detain you. That would be considered the same thing. They're trying to put themselves out in a position of authority. The one that's not obvious that people forget about are park rangers. Park rangers, forest rangers, those are police too. They have the ability to write you a ticket, to detain you, to arrest you. They carry guns, they carry handcuffs. You don't see it happen very often. Usually they just write a ticket and let you go, but they have the ability to arrest you. At least most of them do, depending on who they are. So what are the actual duties of the police? And I've been meaning to add it into the slide, but I have the general orders of Sacramento County Sheriff's Department. And it pretty much says this, not explicitly, but the duties of the police are to protect private property, generate revenue, and social control. All right. On the cars, you might see to serve and protect. That's not their job. That's the perception of people. That's maybe what we wish the police did. But their job is law enforcement officer. All right. They are there to enforce the law. They're not there to enforce morality. Never confused right and wrong with legal and illegal. Those are completely different things. So I have right here that the police have no legal duty to respond to emergencies, investigate crimes, save people in distress, or take any action towards any crime or any emergency. A lot of people are surprised by that. But you cannot, if you have an emergency happening, you call the police and say, hey, I need help right now. This is urgent. This is an emergency. And they don't respond, you can't sue them. They had no legal duty to respond. All right. So keep that in mind. So here I have a vehicle section code that says CHP may investigate accidents. They could. They don't have to. So I also have another case there that talks about this very thing. If you are interested, let's see. Can you repeat that? Castle Rock versus Gonzalez. I'm not familiar with the case name at least. But all I was saying right now is the police have no legal duty to respond to emergencies, to investigate anything. If you call them and they don't respond, you cannot sue them. Did I answer your question, Rachel? All right. And Castle Rock versus Gonzalez, I'm not familiar with, but yeah, it's possible that that's one of the cases that deals with this as well. It's been decided numerous times from at every level of court, including the Supreme Court, that the police have no legal duty to respond to an emergency. Maybe there's an internal administrative rule that says they have to, but as far as what the law says, they don't have to. Okay. So we're gonna start getting into the meat and potatoes here of what to do during a police encounter. This is probably the most important slide of this entire thing. Your number one priority is your own safety. All right. So how do you best ensure that you're going to walk away alive, unbeaten, beaten, is you always do what an officer physically tells you to do with your body. All right. So that doesn't mean talk. That means if they tell you to get out of the car, get out of the car. They tell you sit down, sit down. Take your hands out of your pockets, do it. All right. Well, while you are detained, and we'll talk about what detainment means, but while you are detained, you have to do what they physically tell you to do with your body within reason, you know. Don't jump off a bridge or something, but it's something within reason. You are legally obligated to do it. If you don't do it, they can hurt you. And there's not much anybody can do about it, unfortunately. Again, I'm saying things that are the rules that I don't actually believe, but that's the rule. They can force compliance using violence. And then we wouldn't be able to sue them later if they had a justification. They said, get out of the car, and you said no. They dragged you out. Yeah, if they had reason to detain you at least. So, and we're going to get into that, what all that means. Your second priority, to gather information about the officer and the situation. Information we as at a civil rights office would want to know. What's the name of the officer, the department they work at, and the date and location that it happened. It's helpful if you know the names of any witnesses that we're able to see, or if there's business owners that we're able to see. If you can look around to see if there's any videos or surveillance systems that might have caught it on camera. All that information is very helpful. If the officer is not displaying any type of identification, sometimes they'll just be wearing a badge and there's no name tape, and you don't know what they're called. You can ask the officer for their name or their badge number. Or you can ask for both of them, but they're only required to give you one. So I put the law here, California Penal Code 830.10. Any uniformed peace officer shall wear a badge, nameplate, or other device which bears clearly on its face the identification number or name of the officer. So by law, they need to be wearing what their name is on their outermost garment. But if they're not, they have to tell you. They have to tell you their name. If they don't, like if you ask 2 or 3 times and they've refused to give you their name, again, your rights are not enforced on the street. Don't argue with the cop. Make a note of it, tell your attorney, and we'll deal with it at that time. But don't sit there and get into a verbal sparring match with a cop, because you have no power in that situation. You have no power at all. And it's unfortunate, but yeah, we shouldn't be talking to the cops in the first place. We're gonna get into that, but yeah, don't argue. How to behave. So what should your demeanor be? Calm, cool, collected, and quiet. You shouldn't be saying much of anything. Even if they're asking you questions, you shouldn't be talking. But if the few times you are going to ask, be polite. Yes, sir. Yes, ma'am. No, sir. No, ma'am. Again, don't start yelling or arguing with the cop. If anything, just stay quiet. Don't. I watch a lot of videos of people trying to exercise their rights and people getting the rights violated, both here at work and and on YouTube. And it really annoys me when people yell, "I know my rights." If you knew your rights, you'd be quiet. Don't tell them you know your rights. Show them you know your rights. All right. But yeah, this is just a little pet peeve of mine. And this is a very important point. The sign that she's holding, and it raises the question on what we expect of our officers and what we expect of our citizens. We live in a world where trained cops can panic and act on impulse, but untrained civilians must remain calm with a gun in their face. All right. Imagine how an officer would react at any type of, you know, aggression, real or imagined. They freak out. They act on impulse. They'll pull their guns. They'll shoot. Oh, I thought my life was in danger. But, but we're expected to remain calm at all times. And if we don't, it gives them some reason to either search us or detain us or charge us or beat us. So the standard is different. Don't fool yourselves. But the way the laws have developed and are written right now, it's up to us to be calm. It's up to us to know what our rights are, to know what the law is. If not, that gets me mad. Okay, let's move on. Filming the police. This is California specific, and I'm saying that because I know this for a fact. Most states this applies to as well, but not all of them. Illinois specifically has some weird stuff going on in there. But in California, you can always film the police in public or when no one in the immediate area has a reasonable expectation of privacy. Reasonable expectation of privacy. That's what they use. That's the plain view rule that the cops use to, well, a lot of people have been arrested under it. If they can look, if they are in a place they can legally be and they can see something that's illegal, like through a car window, if they look through a car window and they see drug paraphernalia, that's probable cause to conduct a search. That's probable cause to arrest, because you didn't have reasonable expectation of privacy. You just had it out in the open for anybody to see. But the same rule applies to them. If an officer is working for the public, in public, they have no reasonable expectation of privacy. You can film them. If somebody can put up a security camera that can film them, that's no different than you holding your phone and filming them. Okay, it's the same thing. You're filming the exact same thing. Where might you need permission? Inside a private house, inside private property, in a place that's not observable from a public easement or a public road. So in those cases, you might need permission, but like 99% of the time, you could probably film, especially if you're out on the street. That's where most police encounters happen. Now they might try to intimidate you, not to not film. They might threaten to confiscate your camera, to arrest you, and they might be able to subpoena your film, your camera. That's true. They might be able to subpoena it, but they can't confiscate it. They can't arrest you for it, for filming in itself, just for filming. If you're trying to obstruct them, if you're getting in the way, that's something else. But just for filming, they can't do anything. In fact, in the penal code, what the catch-all is 148. That's the obstruction or delaying or resisting an officer, which they can use in almost any situation. But the very last subsection of 148 says that anyone trying to film is not violating 148. So as long as you're just filming, it's specific in the penal code. And I'm actually going to write that down to include that in the training. This PowerPoint's always evolving. So bear with me while I write this down. Okay. So magic words when you're trying to film. I have my phone right here. So if I'm trying to film something, you see the cops beating a guy, and you're trying to film, usually they'll have people trying to push you away. They'll be like, get back, get back, get back. Cops will try to encircle whatever's happening and they're saying, get back. If you're filming, just keep filming and say, I'm not interfering. 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 Just keep saying it over and over. You're going to disarm them to not pay attention to you. They'll go somewhere else. All right. What they don't want is for somebody to come in and kick the cop in the face. Well, they don't want you to film, let's be honest. But even more of a concern, they don't want somebody to kick the cop in the face who's trying to arrest somebody or who's wrestling with someone. If they try to search your phone, you can say, I do not consent to a search, or you can say anything that kind of means that. You don't have to use those words. You don't have to make it sound fancy. You can just say, no, you can't search my phone. No, you can't search me. No, you can't search my property. So but you have to give them an affirmative no. You can't saying, why are you searching my phone? Why are you doing this? Why are you holding me here? Why? Those are questions, all right? If that's submitted in court, you're not denying consent. So you actually have to deny consent to a search. If not, if they're doing the search right in front of you and you don't say the words, no, don't search, I do not give consent to search. If you don't say something to that effect, it could be considered a legal search. Silence is consent when it comes to these situations. All right, we're going to talk more about that later, but you have to say no. You have to say, don't search. Don't ask, why are you searching? Say, don't search my property. Don't search my phone. Sorry if I'm banging on things. All right. Stranger danger. This is a somewhat of a new slide. And because I want to change people's mentality about how they think about the police. The police it's a dude in a costume. All right. He's no different than you or me. He doesn't have any magical powers. He's just a guy. Imagine he's not wearing the costume and he looked like this creep with the mustache. And he came up to you and be like, hey, what are you doing here? Where are you going? Where are you coming from? How much have you had to drink? Would you tell this creep anything? Would you answer any of those questions? No. Why? Because it's none of his business. It's none of his business where you're going, where you're coming from, how much you have to drink, what's in your pockets. It's none of their business at all. So why are we talking to the police? All right. Their job, what they're doing at all times is to collect evidence, kidnap you, not the legal definition, but just take you against your will, lock you in a cage, and take your money. They're trying to collect evidence to help them do that. Why would you help them do that? That doesn't make any sense. Why help them hurt you? If you wouldn't give that information to a random creep, you probably shouldn't tell a cop, because the cop's actually going to use it against you. They will use it against you. You're just helping them. Anything you say, you're just helping them. 1 second. I have a friend who wants to join. Let me send the link real quick. Okay. Yeah, so stranger danger. Stranger danger. That's a creepy looking dude. Let's talk about probation and parole. So, because a lot of the stuff that I'm going to be talking about doesn't apply to people on probation and parole. Um, so I have the penal code here. A person on searchable probation or parole may have their person, home, and any property under their control searched without a warrant or probable cause by any officer or corrections officer. So think about that. A correction officer, somebody that works at a prison, can go to your home if you're on searchable probation or parole and conduct a search. That's kind of creepy. You can be searched for any reason or no reason. It's kind of the same thing, but yeah, they could have a reason or they don't need it. If an officer reasonably believes you are on parole, they may legally search you, even if you're not. So let's say the officer was aware that you were on parole, but maybe you just got off, just a couple of days ago, you got off parole. If the officer still thinks that you're on parole and they search you, unfortunately, that's legal. People versus Douglas. It's kind of a silly rule. I don't agree with it, but that's the rule. Officers must have probable cause to believe the home they are searching belongs to a person on parole. So that's all they need is probable cause. Probable cause is not 100%. Probable cause means that's probably it. It means this is probably the house that we're supposed to be searching. Someone's joining. All right, so probable cause isn't 100%. It means more than likely that's the case. And there's the case, U.S. versus Granberry, if you'd like to look up the citation. If you are on non-searchable probation, tell the officer you are non-searchable. And you should know this when at your parole hearing or whenever they give you the terms of your parole, if you're searchable or non-searchable. A lot of times an officer will ask, are you on probation or parole? And if you're on non-searchable, definitely say, I'm on non-searchable probation or parole. And where you get non-searchable probations are things like child support. So you weren't caught with drugs, you weren't caught possessing anything illegal, but because you didn't pay what you should have paid, it was a crime. But that doesn't mean they can search you. The probation or the searchable part of searchable probation or parole has to be able to reasonably connect with the original crime. So you see it a lot with drug cases, because if they catch you in possession of something, then it's reasonable that they want to check that you don't have those things again. Weapons charges is another big one. They want to see that you don't have any guns in your car, your house, or on your person. All right. Let's talk about Miranda. Okay. So this is a call I get very often at work. People will call and they'll describe this heinous crime they committed, and then they'll be like, yeah, but the officer didn't read me my rights when they arrested me, so I can sue them, right? Like, we can get my charges dropped, right? No. I've been arrested numerous times, and I've never been read my rights. That's only in the movies. That's only on TV, where you see people getting their rights read as they're getting arrested. Now, sometimes they will do it. They'll read your rights as you're getting arrested. Most of the time they won't, and they don't have to. When do they have to read you your rights? During a custodial interrogation. meaning you are in the custody of the police and they're interrogating you for a crime, for information about a crime. It means you haven't been arrested yet. Okay, you're not in their custody quite yet until you've been arrested. Usually, if they're going to review your rights, they'll have you sign a paper, and it's going to. I have other your Miranda rights here off the side. It says I waive my right to remain silent. I waive my right to have an attorney present, and it's going to say all that. They're going to have you sign and date it. I mean, I don't want to give anybody advice, but it's silly to do. Why would you voluntarily give away information that would be used against you? But a lot of people don't know. That's why we're having these trainings. If you can have an attorney present, if you can have an attorney speak for you, if you can have an attorney let you know what your rights are, then you should do that. A lot of people will talk to the cops because they think the cop will say, "Oh, if you talk to me, I'll talk to the judge, and I'll tell the judge to go easy on you. If you make this easy for us, we'll make it easy for you. The harder you make it on us, the harder it's going to be for you." This is all lies. The judge isn't going to talk to the cop. The cop's not going to talk to the judge. They don't care if you made it easy for the police or not. And one exception is if you're wanted and you turned yourself in, the judge does look at that. But as far as talking to the cop, now, if you're going to admit something, great. It makes everyone trying to incarcerate you, it makes their job easier. If you say, yeah, those drugs that you didn't know who they belong to, they were mine. Thank you. Thank you for that confession. We're going to use that against you. Awesome. So don't do that. If they don't know what belongs to who, then they don't know what belongs to who. And it's their job to figure that out. It's not your job to tell them. All right. Your right to remain silent. This is kind of on the little rant I'm on right now. It's along the same vein. That first bullet point should say may. They don't have to use it against you. It's not will. It's may. May be used against you. Anything you say that can be used against you may be used against you. Now, nothing you say can be used to help you. There's a whole bunch of rules for hearsay and things that can be used to help you that were said could be considered hearsay. But if you admit to anything that's wrong, if you make any admissions or confessions, there's an exception to the hearsay rule called admissions of a party opponent that would allow that evidence to be brought in only if it's used against you, only if it can be used to hurt you, not if it can be used to help you. So that also begs the question, why are we talking to the police? If nothing I can tell the cop will help me, why am I talking to the cop? Everything you say can be used against you. You're not going to talk yourself out of an arrest. All right. Once a probable cause arises, an officer has no duty of further investigation. Once they have you, and that's it. So they don't have to investigate further. They don't have to look at anything else. Once they have probable cause on you and they decide to arrest you, that's it. Anything you say after that is going to be used against you. All right. Anything you say may be used against others. If there's more than one person involved or arrested, you may be hurting a friend, and the cops can lie to you. One tactic they'll use is they'll separate two people and have different officers interrogate the two people in different locations. And then they'll tell each person, hey, your buddy already told us what's going on. So we already know. Why don't you just tell us what's going on too? And you'll make it easy for everybody. But that might not be true. Your friend might not be talking at all. And they're just using that to trick you. So it's legal for them to do, as long as what's coming out of your mouth is voluntary. Coercion in these cases is hard to prove without like something very hard, like they beat you or they put a gun to your head, something like that. It has to be pretty extreme. The more you say, the less likely you'll be able to fight the charge in court. And this is where a lot of public defenders get a bad reputation. People always say, oh man, I got a public defender and they can't help me, or they're not going to work for me, or I know a lot of public defenders. They take their job very seriously. They're very passionate about what they do. But the reason they get this bad reputation is because a lot of their clients talked. Their clients talked, and now they can't help them. They asked a group of people in a car, whose drugs are these? And one guy said, yeah, those are mine. What do you want your lawyer to do with that at that point? You admitted that the drugs were yours. Your lawyer is going to have to try to find some kind of loophole or some exclusionary clause argument in there. But you might have just lost your case as soon as you said, yeah, those are mine. No attorney can beat that. You have to get really creative, and you made your attorney's job and your life a lot harder as soon as you admit, as soon as you volunteered that information. You just made everyone's life a lot harder. So yeah, it's not the public defenders, it's the client talking to the police that makes the public defender's job so hard. But people fall for it. People fall for these tricks that the cops use. And I love this little graphic I have here. You have the right to remain silent. Anything you say will be misquoted and then used against you. All right. So when you go to trial, a lot of times your trial for something criminal is not going to take place for months, even over a year later. They're going to bring that cop on the stand and ask the cop what you said. And the cop's going to say something. Maybe that's not what you said. That was a year ago. Unless they took really detailed notes, they're just going from memory. Some of that could be allowed in court, and you're going to be misquoted, or what's that movie? My Cousin Vinny, when they're trying to do the interrogation, and they're like, yeah, you killed a guy, and the guy's like, I killed a guy? And there's a guy taking the transcription. So the transcript says, you killed the guy, I killed the guy. And taken out of context like that, it sounds like a confession. And I love this Rage Against the Machine quote, go ahead and plead the fifth, your right to remain silent, because you can't plead the first. You can say whatever you want, but they're not going to punish you till after. Thanks, Rachel. All right. All right. So this is a new slide I forgot I made because I was just talking about hearsay rules, but I didn't think I made a slide over it. I don't know if we're going to get into this. Let me see what I wrote here. Pretty much what I said already. I already said all this stuff. But I'll leave it up for a couple more seconds if you want to take any notes. All right. So another one of your Miranda rights is your right to an attorney. It's also in the Sixth Amendment. Your right to an attorney or the right to a lawyer can only be legally asserted by an unambiguous or unequivocal request for counsel. Davis versus United States. What does that mean? That means you have to say the words, I want a lawyer, or give me a lawyer. It has to be unambiguous and or unequivocal. I mean, you can't interpret it any other way. So I put a couple of real life examples of here of wrong ways to request an attorney from People versus Cougar. Maybe I ought to have an attorney. You're asking a question, right? Maybe I ought to have an attorney. That's not unambiguous because it could, there's a question there on what you mean. Maybe you should have one. And this was a big one just a few years ago, maybe 2-3 years ago. During an interrogation, a defendant in Louisiana said, man, why don't you just give me a lawyer, dog? The Supreme Court of Louisiana decided that it's a possibility that this man could have been asking for a lawyer dog. A lawyer dog. That's a possibility. So we're going to deny that he actually requested or invoked his right to an attorney. He said, why don't you give me a lawyer, dog? Yeah, we all feel that. So, and I mean, there's some racial undertones there, but it has to be unambiguous. I mean, I know what he's asking for. The cops knew what he was asking for, but maybe he was asking for a lawyer dog. Right? Now, asking for an attorney, it has special powers, especially during a police encounter. Now, once you ask for a lawyer, technically the officer should stop asking you questions. But if they keep asking you questions and you keep answering the questions, then you just negated your right to an attorney. You negated your right to have an attorney present during their questioning. So even if you say, give me a lawyer or I want a lawyer, and they keep asking you questions, you keep answering, you just made it ambiguous. All right. So you have to say, I want a lawyer, and then stay silent. You have to keep quiet. I don't want to answer any more questions without an attorney. I don't want to answer any more questions without an attorney. Yeah, but where were you on this date? I don't want to answer any more questions without an attorney. Okay, but I hear you, but I'm trying to investigate this thing, and come on, we're gonna go easy on you. I don't want to answer questions without an attorney. That's what it should sound like. You should be a parrot. You should be on repeat like a child playing a game. This is a game. All right. The rule is you have to say these words and shut up. That's what we have to do. I don't want to answer questions without an attorney. Over and over again. First you got to say, don't just say that. I don't want to answer questions without an attorney, because that's ambiguous. I want a lawyer. I don't want to answer questions without an attorney. One second. Got somebody else who wants to join. Sorry, bear with me real quick. go back. All right, we covered that pretty good. Searches, this is a slide I'm working on now. We're reworking. This is all a work in progress. It's always being updated. So I want to show what the difference between a pat down and a search is. First of all, what do we need for a search? You need one of three things. I guess four things. Your consent, or probable cause, or a warrant, or exigent circumstances. All right, four things. Without any of these, they're not allowed to search. If they do search and end up arresting you, finding something and end up arresting you, there's a good argument there for the exclusionary clause to get that pushed out of court. But the big one is consent. So, and the easiest one for them to get is consent. Hey, can I search your car? Yes, you can search my car. Thank you. Now they found something illegal. Now it's admitted into court. If you would have said no and they did it anyway, it would have given your attorney something to work with. But let's talk about the difference between a pat down and a search. So let me use myself as an example. So an officer has the right to pat you down if they believe you have weapons on you, or if you're being belligerent and acting out in a way that could hurt them, they can search you for weapons. So this is what a Terry stop is. A Terry stop is a stop for weapons. And if you'd like to look at the case, it's Terry versus Ohio. It's a search for weapons, but it's a pat down. It's a pat down for weapons to make sure you're not armed. It's not a search for materials. It's not a search for contraband, but they could try to turn it into that. So a pat down is exactly what it sounds like, all right? They're patting you down, right? Pat, 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 you know, they can pat. This is a search. This is not, take my knife out of my pocket. This is a search, all right? They stick their fingers in your pockets, even the little pocket. That's a search. This is a pat down. This is a search, all right? Same in the back. This is a pat down. This is a search. A big one. All right, this is a pat down. This is a search. All right. If you're wearing a hat, patting your head, that's a pat down. Taking your hat off and looking in the brim, that's a search. What else? If you're wearing a coat, if you're wearing a jacket, they can touch the outside and pat it down. Once they reach inside to try to check the inside pockets, that's a search. So know the difference between what's allowed during a pat down and a search. So what should we do if they're conducting a pat down? If they're going to conduct a pat down, you should still say, I don't consent to any searches off the bat. Just anything they want to do. Can I search your car? I don't consent to any searches of me or my property. You should always deny it. If they do it anyway, which they might, they probably will. If they can come up with any little excuse to do it, they'll do it. Keep hearing the door open. So if they can come up with any excuse to search you, they're going to search you, but you should always deny it, because the first excuse they're going to look for to admitting that evidence is your consent. Did this person consent to the search? Your silence could be considered consent. So you should say no. Well, I'm not telling you what you should do. Make that clear. But if they do start putting their fingers in your pocket, say, I don't consent to a search, and say it really loud. Make sure any cameras that are filming hear you. Their body cam can hear you. If they have a dash cam, make sure that can hear you. uh, and make sure that it's very clear. Howdy. Uh, make sure it's very clear that you are not consenting. What you should not do if they start sticking their fingers in your pockets is slap their hand away. All right. No, they're gonna search you. If they're putting their fingers in your pocket, say, "Hey, your finger's in my pocket. I don't consent to a search. Get your finger out of my pocket. I don't consent to the search." All right, that should startle them enough that they stop. But if they don't, at least your attorney has something to work with there. And I'll be filling in the slide with some of that information. I'm trying to think about how to fit what I just said into a slide. So, warrant. This looks like another slide I'm working on. Okay. And I don't know where I was going with that warrants one, but all right. So there's a few stages to a police encounter. One's a consensual encounter. This is stage one of 3. Usually with a consensual encounter, you haven't done anything wrong. Maybe the cop doesn't think you've done anything wrong. Maybe they have, and they're using it as a pretext. But this is like you asking a cop for directions, talking about sports with a cop while waiting in line for food. That's a consensual encounter. All right. A consensual encounter can easily lead to a detainment. All it takes is a cop to notice anything illegal for you to say that you've been involved in anything illegal. You and your friends in line talking about how you were fishing without a fishing license. The cop in front of you is like, "Oh yeah, you just admitted to a crime in front of them. Now they have you've admitted to a crime. They have probable cause right there." So in the context of activism and protesters, a cop might come up and ask, "Hey, what are you guys doing here? How long are you going to be here? Who's the leader?" All those are questions to get information out of you, intel out of you. And those are consensual, but you don't have to answer those questions. So what can you do? You can walk away. It's probably the best thing you could do is just ignore what they said. I know it sounds rude. Ignore what they said, turn around, walk the other direction. Don't give them a chance to find something to detain you with. You can remain silent. You don't have to answer the questions. You can always refuse the search or decline a search. They might search you anyway. They might ask to search your backpack for everyone's safety. "Hey, we're at this festival. You mind if I search your backpack?" "Yes, I do mind. Have a nice day." Walk away. Things you can ask: "Am I being detained?" You're not detained, then you're free to go. If you're trying to film something and they tell you to leave, you can still ask, "Am I detained?" They say no, then you're free to stay. If you're free to go, you're free to stay. That makes sense. I don't want to answer questions without an attorney. I want an attorney. I don't consent to search. All right, we have a question from Michelle. "You don't have to tell them your name. Is that California specific?" Great question. So, and this is important because right next door in Nevada, Nevada is a must ID state. So for any reason, if the cop asks you to identify yourself, by law, you have to, this might have gone to the federal Supreme Court, and I believe they upheld it. I believe that's right. I have to look up the case again. But so Nevada is a must ID state. California is not a must ID state, but it's like a pseudo must ID state where technically you probably, and there's some gray area here. You probably have to identify yourself if you're detained. Not if you're not during a consensual encounter, but if you ask, "Am I detained?" and they say yes, you might have to ID yourself. But when I say ID yourself, I'm not talking about driver's license. I'm talking about giving your name and birthday. We're going to get into this in a bit, but you only have to supply a driver's license if you're driving, all right? Not as a passenger, not walking down the street, not riding a bike. If you're driving a motor vehicle, then you have to possess your driver's license. If you're not, you don't. If there's any way, if there's a reason that they need your ID, you can give your name and your birthday. So what does it mean to be detained? There's two main levels of police detainment. There's reasonable suspicion, that based off reasonable suspicion, and detainment based off probable cause. Reasonable suspicion is the lower level. And this is laid out again in Terry versus Ohio. And there's three elements to it. It has to be, reasonable suspicion is an officer's reasonable, articulable, and specific suspicion that criminal activity is afoot. Those are the words of Terry versus Ohio. So they need those three things. It has to be something reasonable, something they can say, articulate, that's specific enough, that's tied to something criminal. Easy ones that cops will use are loitering. They'll say, oh, well, you're loitering here, or you're trespassing. And then they'll try to use that as their reasonable suspicion. And sometimes that works, sometimes it doesn't. It depends on what's actually going on. As a citizen, as an individual, how do you know if you're being detained? You'll know you're being detained when you have a reasonable belief that you're not allowed to leave. So if you don't feel like you can walk away, you're detained. If they tell you don't move or stay where you are or stand right here, as soon as they verbally start controlling your movement, you're detained. You can always ask if you're being detained. They might try to skirt the question, but if you're asking if you're being detained, try to get a yes or no. All right. Well, I'm just here to ask you questions. Well, you didn't answer the question. Am I being detained? Well, I need to ask you about this stuff. I'm trying to figure out what's going on here. Yeah, but you didn't answer my question. Am I being detained or am I not being detained? Well, you're not being detained. Have a nice day. Thank you very much. Walk away. All right. And then if you are being detained, on the other hand, yes, you are being detained right now. Okay, I want a lawyer. I don't consent to any searches, and I want to remain silent. And I think that's on the next slide. Or maybe on the next one.
Can I ask you a question?
Oh, I can hear somebody.
Sorry. I thought it was easier than writing it out.
Okay.
How often do you find that reasonable suspicion is like something you can challenge? Like, is that even challengeable at all, ever?
Yeah, it is. How do what's a good example? I saw a case where I love and hate these people at the same time. These people doing First Amendment challenges on YouTube because they're doing a good thing, but they don't know exactly what they're doing. And they do it wrong, but this guy accidentally got it right. So he's filming a police station. Cops come out there and they're like, oh, what are you doing out here? And he says, I don't want to answer questions. And he starts walking away. And the cop's like, hey, I'm talking to you, runs after him, grabs him by the shoulder, throws him against a fence and starts handcuffing him. So the officer didn't try to control his movement. He didn't say stop, freeze, don't go anywhere. He didn't tell him he was detained. He starts asking him questions. The guy said, I don't want to answer it, and walked away. So in that case, the officer did not have reasonable suspicion. The guy was conducting a First Amendment protected activity. He wasn't breaking any laws. Just the police thought it should be illegal to film a police station. And that was his reasonable suspicion. that's not a real thing because that's not a crime.
So he was able to corroborate what he was saying with video evidence?
Yeah, he was filming and the cop had
Okay.
body cam also, and the
So,
officer was disciplined, and I believe he got something like $20,000 out of it.
okay. So obviously there's many cases when people aren't videoing their interactions. So would you say it's like harder to fight those situations usually?
Absolutely. So of course, videos, very good evidence, and almost indisputable evidence if filmed correctly, if the audio is right. Um, and it is a lot harder to win a he said, she said thing, but it's not impossible because you put the cop on the stand and you ask, let me go back to this slide over here. Excuse me. Ooh. Where are we? Okay, so for reasonable suspicion, you put the cop on the stand and ask what the reasonable, articulable, and specific suspicion was that criminal activity was afoot. What crime do you think this person was committing? And more often than not, the cop's going to be like, you know, there was no crime this person was committing, even if there was no evidence.
So they have to articulate a certain crime. They can't just say like they were using furtive movements or like, you know, just looking suspicious generally.
With the furtive movements, usually you're detained already.
Okay.
So when they try to use those excuses, I mean, if there's no reason you shouldn't use a furtive movement because you're just out living your life, then you didn't do anything wrong. Now, if you're detained, you should mind your movements.
Okay.
But if you're not detained, there's no reason why you can't do what you want. But yeah, if you sued a cop in a civil rights action during their deposition, and even during your criminal trial, they'll bring the cop up there, and your defense attorney will ask the cop to explain what their reasonable suspicion was. They want to know what the underlying crime was and how your actions, can you articulate the specific circumstances that gave you that suspicion that this crime was being broken? And they'll attack it from all angles. Did I answer your question?
Yep, thank you.
You're welcome. All right. So how long can you be detained by the police? The purpose of the detention, the way it's supposed to be designed is it gives the police time to investigate their suspicion. So they see something that, you know, oh, they might be doing something illegal here. Here's some facts that I have of the situation on why I think that. Now I can investigate now that they're detained and they can't move. And they can detain you until the suspicion is confirmed or dispelled. So someone's joining here. So you can, until the suspicion is confirmed or dispelled, and it could be like you might match the description of someone who just robbed a store, and so they'll hold you there. They have reasonable suspicion to think that might be you because you're in the area wearing the same clothes, but they'll bring the storekeeper over and be like, hey, is that the guy? Storekeeper says no. Well, you're no longer detained. They dispelled the suspicion. Or the storekeeper could say, yeah, that's the guy. Now they've confirmed it, and now they have probable cause to arrest. So that will lead into the probable cause. So from case law, we know detaining you for 24 hours is too long. But other than that, it has to be reasonable to the circumstances. So they can't detain you for 24 hours for stealing a pack of gum. But they might be able to do that for a murder, you know, for them to properly investigate circumstances of a murder. They might be able to justify 24 hours just because of the seriousness of it. But it's a totality of the circumstances type analysis. So what are your rights when you're detained? You can refuse to answer questions. I say speak, but you can refuse to, I need to change that too. You can refuse to answer questions. You can refuse searches. Doesn't mean they're not going to search you, but you should always refuse the search. I crossed out you don't have to identify because the rule on that is gray. It might be in your best interest if you are detained to identify, but if you have maybe reasons not to, for one reason or another, that's up to you. If you don't identify, you could be charged with 148. It's a minor crime. It's pretty minor. Maybe it's worth it. Who knows? That's for you to decide. But you cannot leave. When you're detained, that means you are under their control. You cannot move your body any way you want. So you have to assert your rights. Silence at this stage can be used against you, and silence is consent. And one of the places, one of the places you'll see this a lot is in car searches. They'll take you out of the car, have you stand by their car, and then they'll tell you, they're like, I'm gonna go ahead and search your car, okay? Okay, and then they walk to your car and they search it, and you didn't say anything. So if they say that, they say, I'm gonna go ahead and search your car, okay? They start walking to your car, you gotta say, no, you're not. I don't consent to a search. Well, if you don't consent, we're gonna bring in the dogs. I don't consent to a search. Do what you gotta do. And some people might ask, well, why don't I just let them search if they're gonna bring a dog? I'd rather have them search than have a dog. And that's a decision for you to make. But the thing is, if you say no and they search anyway, your attorney has something to work with. Even if the dog finds something, your attorney has something to work with. Because there's cases that say that they can't detain you for longer than reasonable for them to issue that whatever citation they're going to issue you, right? What's the case? Rodriguez versus US, something like that. It's a police dog case. And they held this guy over for like 5 minutes. No, it was longer than that. It was like 20 minutes. They held him for 20 minutes, detained him 20 minutes longer so they could get a dog out there to search it. And the dog did find something, but the court ruled that they detained him without really anything. They wanted to write him a citation for like a parking light, and they could have easily done that citation in that time, and they held him longer on nothing just because they wanted to run a dog by his car. But the court said no, that's not allowed. Oh, Rodriguez versus US. Whew. All right, that is correct. Thank you very much, Michelle, for that quick research. All right. Oops, where are we? All right, and magic words while you're detained. Again, am I free to go? And am I free to go is the same as asking, am I detained? It's two different ways to ask the same question. If they say no, you're not free to go, you're detained. If they say yes, then get out of there before they change their mind or find an excuse to hold you. Again, I don't want to answer questions without an attorney. I need to add, I want a lawyer. That slide is fairly new where I have specifically, I want a lawyer. So I need to write that down. Okay. And of course, I don't consent to searches. We talked about that. You only have to show your ID. We spoke about this before. When you're operating a motor vehicle, so passengers are not required to show an ID. If the driver is detained, so are the passengers, but they're not under an investigatory detention. They're not being investigated for anything. The detention for the passengers is, they say it's for officer safety. It's safety based. So they probably won't allow the passengers to get out and keep walking to whatever the destination was. All right, they'll probably hold you there. And a lot of their reasoning is they don't want you to go out, grab a stick or a weapon in the woods and come back and like help beat them or something, help beat the officers. Yeah, let's go to the next thing. I don't answer questions video. Let's see if this works. So this is a guy that he films a lot of his police encounters, and the only thing he says during these police encounters is, I don't answer questions. And he keeps repeating that over and over. And I love showing this video because it shows how it's done in action. So let's go ahead and watch this.
Is there some reason you can't roll the window down? I saw you roll it up.
I don't answer questions. I don't answer questions.
You don't answer questions?
That's correct.
What's the reason for that?
I don't answer questions.
Hello.
How you doing?
Good. Do you know this lady back there in the accident, or?
I don't answer questions.
Okay. Well, have a nice day, sir.
All right, thank you.
Can I help you? Sir, are you Kenneth Suter?
I don't answer questions. Can I help you?
I was looking for a Kenneth Suter.
I don't answer questions.
You lost?
I don't answer questions.
Pronounce your last name for me.
I don't answer questions.
I'm going to need you to pronounce your last name.
I don't answer questions. It's there on the license.
Okay. Who was the gentleman you were just standing here?
I don't answer questions.
Is there a reason why?
I don't answer questions.
Do you have a nice day? Okay?
You too.
Can you give me your phone number?
I don't answer questions.
Okay, is there anybody here that can answer questions?
Don't answer questions.
Okay. I'm not sure how to respond to that, sir.
Sorry. Okay. Have a nice evening.
Okay, I'll be back.
Okay, so there's Rachel asked a question. What does he do to get pulled over so often? The answer is I don't know, but it could be any kind of checkpoint. It looks like on a couple occasions he stopped to observe an accident or something, or he stopped to observe cops pulling over someone else. Maybe he was filming someone else have a police interaction, and it looks like the cops came up to him to see what he was doing, or if he was involved, or if he was a witness. So at least a couple of them, I can tell that's what was going on. One, it looked like they tried to serve some kind of warrant or maybe serve process paperwork to a residence. And he just kept saying, I don't answer questions. So, and just, that works. Just keep repeating it over and over and over. People think that they're gonna make cops mad by calling them a pig and, you know, making fun of their mom and, you know, throwing insults at them. That's gonna slide off right off the cop's back. Why? Because he's gonna smile when he puts the handcuffs on you, okay? He's gonna win that day. But if you actually wanna make the cop mad, and this shouldn't be the point of it, but it does irritate them when you don't answer questions, because they're trying to get you to admit that you did something wrong. And as soon as whatever you say, you're just adding to their probable cause and their reasonable suspicion. You know, for example, where are you coming from? I'm coming from the bar. Okay, how many beers have you had to drink? Well, I've had 3 beers. Came from a bar, said he had 3 beers. They had that, you just gave them probable, reasonable suspicion, and you helped with your own probable cause to get yourself arrested by answering their questions. All right. Where otherwise, if you wouldn't have answered those questions, they would have never known that, and that would have never gone into their report, and that wouldn't be used against you. So, yeah, just more stuff to think about. I don't know what this is. Okay, stage 3, arrest. Let's try to get through this in the next couple minutes. So what does it take to arrest you? So our first level for detainment was reasonable suspicion. That's the lower level. That's to detain you. To arrest you and to search you, they need probable cause. Probable cause is established with an office when an officer has gathered evidence that a suspect probably committed a criminal violation. And look at that word, probably committed a criminal violation. So they have evidence that you probably did it. Doesn't mean you did it. That's what a trial is for. But they have some evidence, something. I mean, it doesn't even have to be tangible. Some circumstantial evidence, even that you committed an offense, that you probably committed the offense. That's probable cause. Doesn't mean you did it. So, yeah, people always say, "Oh, yeah, if you didn't, you have nothing to worry about if you didn't do anything wrong." Well, yeah, that's not exactly true. If they think you probably did something, you might get arrested for it, even though you didn't do it. If you match a description, you're just minding your business, walking home. Somebody called a robbery down the street. You just happen to be wearing the same thing that was reported. You know, something common. They'll say, yeah, there's a male subject, beard, black over blue. So black over blue jeans. That's common. People wear blue jeans. People wear black shirts. People have beards. That's not that specific. But I could be detained and possibly arrested for something I didn't do. And that's common. So we need to rethink what we blame people when they're accused of something, or how hard we blame them. See, how do you know if you're under arrest? You can ask. I actually just found this penal code the other day, well, a couple months ago. I went ahead and put it in here. The person making the arrest must, on the request of a person he is arresting, he or she, inform the latter of the offense for which he or she is being arrested. So they have to tell you. I didn't know that. I didn't know they had to tell you you're being under arrest if you asked. So now we know. It seems like something simple, but they don't have to tell you a lot of stuff. So that's why it came off as kind of a surprise. If you're under arrest, you're likely already handcuffed. But just because you're handcuffed doesn't mean you're under arrest. So you could be detained and handcuffed. And the situations that might involve is, let's say there's 5 people in a car and 1 or 2 officers. So they might get overpowered if something happens. So they might detain you and then cuff some people and put them in different vehicles and put them in the back of police cars. That doesn't mean they're under arrest. All right, just because you're handcuffed doesn't mean you're under arrest. They'll handcuff you in order to intimidate you. They're like, oh, you don't want to answer my questions. Okay, turn around, and then they handcuff you. And it could be a violation if there was no real underlying reason for that. It might be hard to prove, but it's another thing for your lawyer to look at. If you're arrested, okay, so sometimes you could get cited and released. They'll write you a citation, you sign the promise to appear. That is an arrest. If you've ever been given a citation for something, you've technically been arrested. That means they had probable cause to arrest you, but they let you go. But you're still charged. You still have to go to court. You still have to pay a fine. There could be a trial. You've been arrested. All right. So a citation is an arrest. And again, they're probably not going to read you Miranda. So don't expect that. And that's, if they don't, they probably won't. So, and we talked about Miranda earlier for people in the group that didn't catch that part. What are your rights during the arrest? You have the right to remain silent. You always have the right to remain silent. You should always use it. You have to invoke it. You have to say, I don't want to answer questions. You can say, I plead the fifth if you want to be fancy about it. If you are arrested, you will be searched. You can still say, I don't consent to be searched, and you probably should. Because if it was a wrongful arrest, you don't want to give them permission to search you, because if they find something, it might be used against you too. So even though you will be searched when you're arrested, make sure they know that they don't have your permission. So it cuts out that excuse of, even though we didn't have probable cause or a warrant or an exigent circumstances, we had their consent. So it's going to be allowed in court. It might be allowed in court. Don't give them that excuse. Make them get the warrant. Make them have probable cause. And I didn't go over what an exigent circumstances was. That means it's almost like an emergency circumstance. The example that's often used is cops are chasing a suspect, and that suspect runs into a random house. Ordinarily, the cops would not have the right to enter that house without consent, a warrant, or probable cause. But if they're chasing somebody, they can run into that house after them. That's an exigent circumstance. Now, anything they find in that house that's illegal, they can move on. It would be a legal search or a legal discovery. All right. If they're chasing somebody, that person runs into a random house, and there happens to be a meth lab in that house, well, the police can legally act on it because they had a exigent circumstance for going in there. So that's what that means. When you're arrested, your wingspan may be searched. So what's your wingspan? It's probably going to be searched. All right. So your wingspan is this. Anywhere you can reach from the place you were arrested is your wingspan. So a lot of times when you watch cops or live PD, they'll arrest somebody, they'll take them out of the car, arrest them, and then you'll see the officer sit in the driver's seat. And they don't tell you what he's doing, but that's what he's doing. They're doing a wingspan search. So he sits in the seat, and then he reaches under the seat, see if there's anything there. He checks the glove box. So he's searching anywhere he can reach from that position. They check the visor, they check the center console, they might check up inside the material, the ceiling of the vehicle, behind the seats if there's any pouches. So that's what they're doing. They're doing a wingspan search. And I'm drawing a blank on the case that allows that, but there's case law on that, and I'll be adding more and more case law as it comes up. So when you're under arrest, what are the magic words? I don't want to answer questions without an attorney. I want an attorney. I don't consent to searches. I should write more of these on here. But don't give them permission for anything. If they have the legal right to do it, they'll do it anyway. But as long as they don't have your consent. Chamel versus California. Thank you very much, Michelle. That is correct. That is the case. That's the wingspan search case. I'll write that down so I can add it. Okay. All right, we're almost done here. So interrogations, if you're arrested, you may be interrogated depending on the crime. If it's something petty, they're not going to bother. But this is one of the tactics they use, good cop, bad cop. Usually they'll start with the bad cop, and the bad cop will come in and insult you and threaten you and yell at you and call you names and what do you have to hide and you're a piece of shit and don't make this harder on me or I'm gonna make it harder on you. And then the good cop comes in, it's like, hey man, partner, why don't you calm down? Why don't you go get a drink of water? I'll talk to him. I'll take over from here. And when that good cop comes in, you feel relieved because this guy's not yelling at you anymore. And this guy's being buddy. Maybe he brought you a candy bar and a soda. He's like, hey buddy, I'm on your side. We're just trying to figure this thing out so we can all go home. And the faster we can figure this out, the faster you can go home. If you talk to me, I'll talk to the judge, I'll talk to the DA. Things will be a lot easier for you if you just tell us what happened. You'll see this a lot on cops and live PD. They'll pretend like the information you're about to say is no big deal. So in states where weed is still illegal, they always do that. They're like, what do you got in the car, man? Is there a little weed? Is that it? We're not looking for weed, man. We're not looking for weed. We're looking for guns. We're looking for, stacks and stacks of money. What, you got a dime bag in there or something? Yeah, it's not a big deal. Where is it? Why don't you tell me where it is? Oh, well, it's under the seat. Now, you just admitted to a crime of possession of drugs. You've told the cop where it is in the car, so you can't deny and say, I didn't know it. And you just gave them probable cause to search your entire car. So you just gave them everything. And the cop was acting like it wasn't a big deal. It's like, where's the weed? Is that all you got? That's it? Just a little bit of weed? We're not looking for weed. But they'll get people to talk like that. It happens all the time. And the correct, well, in my opinion, the correct response would have been, no offense, officer, but I don't want to answer any questions at this time, and I don't consent to a search of my vehicle. I want a lawyer, and I don't want to answer questions without a lawyer. That should have been the response. And then shut up. And anything asked after that should be a portion of what I just said. I don't answer questions. I want a lawyer. I refuse searches over and over again. Booking into jail. We're going to skip this. Let's talk about warrants. I think we have like 1 or 2 more slides left and we'll be done. So when police or immigration come to your door, if they have an arrest warrant, they still need some type of reasonable suspicion that you're in the house. They need to have seen you go into the house and not leave. Your car might be out front. They need something that you're in the house. They can come in your house just like probable cause with everything else to search. They need a warrant, probable cause. Probable cause could be plain view rule. You had your window open and they saw drugs on the coffee table. That'd be probable cause using plain view. Exigent circumstances like chasing another suspect through the house. You are free to refuse the search and you're free to remain silent. Remember, remaining silent still means you have to invoke your silence. You still have to invoke all your rights. Just don't answer the questions. We don't give consent to search our house without a warrant. I don't want to answer questions. So what do you do if you think your rights were violated? This is very important because people get this confused all the time. You have, this is California. I don't know about other states, but this is California specifically. You have 6 months from the day of the incident to file a government tort claim. You have to do this. You won't be able to invoke your rights or sue if you don't file one of these claims. People think that they don't have to do this or they don't have to start this process until after the criminal proceedings are done. No, that's wrong. It's from the day of the incident. That's when the time starts. 6 months. The other thing you can do is file a citizen's complaint. This is a complaint by Internal Affairs. It's mostly useless. It's mostly symbolic because they probably will say that we did nothing wrong. But the reason you still want to do it is because it gets put into the officer's file. And later on down the road, if somebody else has a complaint about the same officer, the attorney can request what's called a pitches motion. And a pitches motion will have the judge look through the officer's file to see if there's any complaints that deal with the same subject that that attorney is dealing with. And if they do, then the attorney will have access to that to help their defendant. So that's one reason we do it at our office, even though we know probably nothing's going to come from it. But it is worth the work to put it into the officer's file so that later on down the road, if we have another issue with this officer, another attorney has another issue with this officer, at least there's a record of it. So you can also ask the National Lawyers Guild, and we'll try to direct you to resources that can help you and maybe get you a consult with a civil rights attorney. So things to remember: always comply with orders regarding your movement. That's number one. If you take anything else from this, it's always comply with orders regarding your movement. Shut up and do what they tell you to do with your hands and feet. All right. Never give permission to search or yourself or your property. Always tell them they do not have permission. Always remain silent. Ask for a lawyer. And here are off to the right are these are the only things you should be saying to the police. And this is to protect yourself. If you follow this advice on this page here, this is everything we went over boiled down to one slide. If you do this, this gives you the best chance of walking away with your life and beating the rap in court. It gives your attorney the best ammunition to help defend you. All right, that's what this whole presentation was about, is giving your attorney the best ammunition to help you beat your case. And I have Border Patrol checkpoint. Got some video there. Yeah, so that is it. If anybody has any questions or you want to make a donation to help with these Know Your Rights trainings, we give them all over Northern California, especially Sacramento, since that's where we're based, but we've gone out to Mendocino and other places in Northern California to give these trainings in person. We do them to communities of color, to poor communities, to activist groups. So you can go to our website. I believe it's nlgsacramento.com, and give us a donation there, make a request there, email us there, and direct any of your questions to us. All right. Does anybody have any questions before we go? All right. I'm going to try to get a recording of this presentation out to the public so we can post it up and spread more of this information. But thanks for hanging out with me, and I'll see you next time.